Hi, I'm Brad Hunter, family mediator, family arbitrator, and family mediator arbitrator for that process as well. I want to talk to you today about the new judicial case conference system, known forever after this as the JCC. You'll become very familiar with it as time goes on. So I'm just going to walk through this as quickly as I can to give you a brief overview of what that looks like or what it will be like. So first step is to look at what it is. The stated purpose of it is to streamline the court process and reduce court costs. It's stated to be a pilot project. It applies to Regina and Saskatchewan judicial centers only. It was announced on October 4th and it's effective November 1st. So you've had very little time to prepare for it. In my view, it's the most significant change to family practice in 40 years. A couple of main points. It applies to all family cases in Regina and Saskatchewan unless it's exempt. Just assume it applies to your case. And the principal rule is you cannot serve or file an application or a parent's day notice or file any affidavit material until the JCC judge allows you to proceed. So everything is without evidence. It's done by submission. It's an evidence-less process. What does it apply to? Divorce Act, Family Property Act, Family Maintenance Act, Children's Law Act, the parenting provisions, excluding Section 21, which is about child protection. It applies to notices of application and to parents' day notices. Hopefully I've got all of them. What is exempt? Well, an application to vary a final order. The judges felt that the rules did not allow them to put it under the JCC, but I think it's clear the court is going to use JCCs, or at least the approach of JCCs in managing these. Other miscellaneous statutes won't be covered, like MEO cases, dependence relief, adoption, child protection, those kinds of notices. Applications without notice in emergency situations. So if you have a parenting issue or an application for exclusive possession that's on an urgent basis, however, you're still going to end up in the JCC process, is my expectation, after you get your order. Applications without notice for some procedural things, service issues, kind of the management ones, mostly uncontested and matters. And please note, you still need to comply with the practice directive because you're going to have to file Form 7-1. There are 5 new forms to look at. The first form is 7-1, the certificate of compliance with the practice directive. Either you'll serve that if you don't need to go to a JCC, or you will prepare that as your last document. 7-2 is a request for a JCC. That is without doubt the most important document you will need to prepare. 7-3 is a joint request. 7-4 is a notice of judicial case conference. So if you get to the point where a court allows you to have it, you will serve that. It's prepared by the court. And then there's an appearance memo at 7-5. I calculated as a 6-step process. First is you'll have to prepare, serve, and file your PD 7-2, which is the request for the JCC. And you'll need to file a detailed order. Second step is it's reviewed by the family law screening officer, who is a lawyer. It may also be reviewed by the JCC deputy local registrar, who is specially trained DLR to review the file, and the triage judge. They will either return it to you with some directions, or you'll be put on to the next phase, the JCC. If you're allowed to proceed, you'll serve the notice of JCC. The 4th step is you'll need to file an appearance notice. The 5th step is you attend at the JCC. We'll talk in some detail about that. And the final step is you will then have your certificate of compliance and you'll file your material only at that stage. So it's the last stage where you finally file an affidavit. So step 1, then you serve and prepare the PD 7-2. Rules around that is you cannot file it any earlier than 3 days after service, and your client must sign. The party must sign. The lawyer is not allowed to sign on behalf of the client. Step 2, I think this is a very important step. You don't get to appear for this. However, you need to ensure that your materials go in, so you will succeed at this phase. This application is reviewed, as stated earlier, by the FSO or the JCC DLR. They will, quote, screen, review, and seek directions from the assigned triage judge, close quote. The triage judge will review all the family PD 7-2s at least once per week with the FSO. The court will do one of two things. Either, if the matter is not ready to proceed, the triage judge will give you directions about what you need to do. It's unclear whether that's given to the other party as well. I assume it would be. So it comes back to you. You don't get past go. You don't collect $200. Or if the matter is ready to proceed, the court issues a notice of JCC that the step 3 is for you to serve the notice of JCC. It's prepared by the court. You're required to serve it on the other party. And unless otherwise ordered, it must be served on the other party at least 7 days before the JCC. There are ways to get that time reduced. You'll need to put that in your Form 7-2 if you're seeking that. And you'll need to file proof of service. Step 4 is you do an appearance memo, filing it 2 days before the JCC. Step 5 is you go to the JCC. It's before a King's Bench judge. The court sets the date. They're held on Thursday afternoons or Fridays, and you must attend in person. There is the ability to request that you appear by phone. I assume it will be under the normal circumstances that that's allowed. The purpose of the JCC, this is directly from the practice directive, I believe. Have the rules been complied with? This is also what's looked at step 2. Should you use an ADR process instead? Even if there's been mediation or some other form of formal ADR, the court can always say, well, have you or can you settle this motion without this application without going forward? Can the issues be simplified? The court may then set a number of dates for things to be done. I suspect that will happen a lot and the matter will be adjourned. The court has case management, resolve practice, procedural, or other issues, and how to resolve the case. So note the huge focus on resolution, on doing this by agreement rather than by judicial order. What are the judge's options? To make a procedural order, so this appears can be done even if you object or think it shouldn't be done. Make a substantive order with consent. The court probably will not or cannot make a substantive order without the consent of the parties, simply because there will be no evidence to make that decision. They may schedule another JCC. They may set a chambers date with directions, including when you're supposed to be filing things, what you can file, maybe even they will set the date, set a summary judgment if that's what you're after, or order pretrial. So if you're seeking a pretrial date, they may put you there, or the court may simply say on its own motion that it's not appropriate for it to proceed to chambers, go straight to pretrial. And the final step is your certificate of compliance, which you would serve with the balance of your materials to get the motion moving forward. Getting past the triage judge. So this is where you're completing your Form 7-2 is extremely important. They're looking at whether you're ready to go forward. And my guess is if you have not complied with these various steps, you are not going to go to the next level. Failure for your client to attend the parent education program. I mean, what excuse is there for that if they haven't done it within 2 years? It's an easy one to fix. You'll need to make sure your clients have done that. Failure to file a certificate of participation in dispute resolution. If the other party is not cooperating, you need to show you've done sufficient steps that you may be able to get an exemption or get the court sympathy to move forward. Incomplete documents, where I think our focus may be is the financial statement form, whether it's properly completed and whether you've attached the proper documents, the income tax returns that are required by the rule, that you haven't attempted to settle the issue. So again, motions are different than mediation. I say that as a mediator, you may have 3 or 4 specific things you're seeking in your motion. You need to try to settle those and show some evidence to the court that you tried before you brought your motion, and I'm sure there'll be other grounds. So I keep going to the PD 7-2. It's the critical document. There are 19 paragraphs to complete. It's supposed to be brief. At the same time, it's supposed to be thorough and complete. I appreciate there's something of a contradiction there. You'll need to state facts. You'll need to state the relief that you're after, the law that you rely on. There's some other points you need to review as well, such as compliance with the early dispute resolution process. And if you haven't, why not? So you're going to need to spend a fair amount of time to get this right. Let's say your client is served with a PD 7.2, or you're served on behalf of your client. How do you respond? Well, there's no specific timeframes from what I see in the practice directive. If you want to file your own PD 7-2, so you want to bring your own motion, it seems suggested that you need to do so within 3 days from service. I appreciate that might be very difficult. However, does not seem to be a requirement. And if you don't, your only chance to respond may be your PD 7.5 appearance date notice when you finally get to the JCC. And I think it's uncertain as to whether briefs can be filed at that level. I don't know why they wouldn't be, but the court will, I'm sure, make it clear what you're supposed to do at the JCC. Now, finally, I want to deal with the typical family law matter. So your client comes in, they want something resolved around parenting, and they want something resolved around support, and the other party is either not responding or they simply can't agree. I think you have to take, we'll have to prepare 12 documents at a minimum on behalf of your client to get the matter resolved. The petition, the property statement, the financial statement. Then we get into the JCC process, and you'll need to prepare the PD 7-2. You'll need to file a detailed order at that phase. You'll need to file at 7-5, the Judicial Case Conference appearance memo before the JCC. And finally, the certificate of compliance. Then you go back into your regular process, and you'll need to do your application, your detailed order, which may well have evolved and changed from the original detailed order you sought, then an affidavit, and finally a family chambers appearance notice when you're finally going to chambers. And then, of course, the order of court finally makes. So 12 at a minimum. If you're filing more than one affidavit, that goes up. If you make one or more appearances in chambers or at the JCC, that goes up again. And finally, I think you have to be expected to file at least 2 more documents, the parent education document and the certificate of participation in family dispute resolution. So conclusions, I'm going to say consider arbitration or MEDARB. MEDARB is a combination of where you start mediating, and if the mediation fails, you convert the mediation to an arbitration. That might be most effective for your clients, both in terms of cost and time, especially if you and the other counsel have narrowed the issues already. This process will result in delay before you can get matters reviewed, maybe. Court says no. I'll leave that to see how that works. And certainly with respect to cost and focus, you can eliminate the need for many of the documents that need to be filed. So consider contacting me or someone else qualified like me, and consider the options that you have. And I wish you luck with respect to this new system. So with that said, good luck, and I will hope to hear from you. If you have any questions or comments, please let them contact me by email or add them to the comments below. And thanks for your time.